The first states came into existence millennia ago. In order to secure the viability of the societies, some general rules were established. The law came to life to clarify the social relations, to fix the order within any state. The history of humanity was filling in new volumes. Social orders were replacing one another. At the end of the 20th century, a new ideology was born inside the empire, which used to occupy 1/6 of the land. The Soviets were collapsing, and the ruins were becoming the basis for new states. The perceptions of law, right, social relations of the citizens and the state were very new then. The fundamental human rights and freedoms, the bodies of their implementation and protection were established in the Independent Republic of Armenia on July 5, 1995. The provisions of the Constitution, accepted on general referendum, became the basis of a modern democratic legal state. In a modern democratic legal state, the society was expecting a justice of new quality, and the adoption of the Constitution gave a start to judicial and legal reforms. The world is changing rapidly, and we don't have the right to stop. Especially a country which has very limited natural resources. Such a country has to be able to find ways to neutralize the lack of natural resources. And we believe it can be done with the speed of the changes, reforms. An attempt to reform a sphere which had in its basis a collapsed old and yet unshaped present was made in Armenia. The laws were in the initial stage of elaboration. However, there was no land for viability. The justice was executed as a rule in small, unfurnished rooms of shabby buildings. The public would typically prefer to resolve issues on their own, avoiding courts, using traditional, sometimes criminal connections, which brought about new illegal actions. A lack of trust was everywhere. The top issue on the agenda was to change the attitude towards the judicial power. Changes were needed in the style of judges' work. It was necessary to conduct trainings and experience exchange programs, and a number of other events to strengthen management and administration of the judiciary. New approach was required in the judiciary practice, political will and material resources to bring ideas to life. That was the reason why, at the end of 2000, we negotiated with the World Bank and agreed on a provision of a loan for judicial reform, naturally with privileged conditions. In the middle of 2001, our agreement became effective and its implementation began. If we didn't have the credit agreement, I can assure you that we would be in a position to find ways to move forward without serious financial investments. That could be a less efficient solution, and we might not have the results that we have today. In any case, you decide on your strategy in the first place, depending on what resources you have, what kind of resources you own. To bring to life the provisions of the concept of judicial reform in Armenia, in 2000, the Project Implementation Unit of Judicial Reform was set up inside the Ministry of Justice. A loan was provided by the International Development Association, complemented by grants received from the Government of Japan and Kingdom of Netherlands. A few target directions were selected for the implementation of reform programs. Each of them had pivotal meaning, a system-forming significance. A vast amount from the credit resources was directed at the construction of court buildings. The reason for that was that in Armenia, court buildings hadn't been built after the independence. The construction of the last court buildings was finished in the Soviet times. By the moment the project began, those buildings had not been renovated for at least 15 years. The court was simply adjusted to functioning along with other institutions. Quite often those other institutions would be police or the prosecutor's offices. That was a consequence of Soviet mentality. Construction of court buildings became probably the first step to change public attitude towards the institution which exists to execute justice. Civilized working conditions for the third authority were to be secured in newly built or renovated buildings that were supposed to match European standards. A tender was announced to do the construction, and a number of companies applied. We participated in the tender, became winners based on all the required criteria, and started the construction. The first pilot project in 2001 was aimed at the reconstruction of the court building in Malatya-Sebastia district. The building was in dire condition. We had 2 unfurnished rooms. The judges simply did not have enough time to accomplish the court sessions. The courtroom was located in such a place that anyone could open the door right from the street and immediately get into the courtroom during a trial process. I have seen the location of court in Malatya-Sebastia district and the conditions of work for judges. The rooms were shabby, it was a half-built condition. The floor was in a disastrous condition and no furniture at all. What was important was what building conditions existed for the judge's work and what was happening after that. Constructors, architects and the client were discussing issues for days on end. Solutions were sought for a long time. All those joint efforts resulted in construction and renovation of 8 court buildings in the capital and in the Marzes by construction of Armenian nuclear power plant company solely. Other companies were involved in the process as well. The first credit line was directed at construction, renovation and modernization of court buildings, mainly in Yerevan and the earthquake zone. This is the former building of the Court of General Jurisdiction of Maralik in Shirak Mars, which used to be a building of Regional Committee of the Communist Party. We were located on the 2nd floor. Here you can have a look at what conditions were before. Everything was broken after the earthquake. The impression was depressing at the very first sight. An artistic school was located on the 2nd floor, where children were doing dancing, and that bothered our work. That was it. And this used to be the door of the former court, which we cannot open as we handed the keys to the municipality. Inside, there was the same broken condition. We did not have proper rooms. The 2 rooms were in the corridor. One room was for the judge, the other one was allocated to the staff. In 2009, this beautiful building was built, where we have already made ourselves comfortable. We expect the judge to inspire trust and respect with his behavior. Thus, justice is better exercised. So if the first condition is the behavior of the judge and his attitude, then the second is building conditions. Before the disastrous earthquake of 1988, in Gyumri Court, justice was exercised in a building built in the 1800s, which used to belong to one of local noble families. The biggest area in the building was given to a stable, and in Soviet times it was transferred into the only court session room in Leninakan Court. The offices were located in the upper floor. After the earthquake, the sessions sometimes were held in a half-destroyed building if the case had public significance and the courtroom was expected to be full, while all other cases were heard in small private houses. There used to be boxes here, 1, 2, 3, 4. And these 2 court garages in the past were used as judges' offices. Come over, have a look. The judge and the secretary used to sit here together. The conditions were terrible. Rats used to sneak under my feet while I sat there. There was nothing to burn for heating. The door would not close. In 1988-89, we worked with the door open. And when we would leave for home, we would usually fix the door somehow using a wooden chip, a pen, to open it again in the morning. The prisoners were brought in during the court session into the small house. I would sit here, and over there the secretary would sit. I'm showing you so you can see. Here the accused, the attorney and two accompanying policemen would sit. And the zone for general public was behind them to let as many people as possible. There were attempts of stealing the court files. Sometimes, even when a judge sat close to the prisoner and was announcing the verdict, the latter would try to tear the papers apart. Yes, such cases used to happen. Not with our court, but at other courts there were attempts of stealing the cases. The new building of the Court of General Jurisdiction of Chirac Mars, which was completed in 2005, is considered to be one of the biggest among the country's court buildings. The Service of Compulsory Implementation of Judicial Acts Department, Notary Office, State Registry and the Service of Alternative Punishments are all located here. Each of these offices has its share in the building's office space, a separate entry. All the conditions have been created in the building to conduct the work properly. The process of building courts is still underway. The building of Judicial Academy is currently being constructed in the capital. The Academy will move to the new building from the buildings of Ajapnyak and Davtashen court buildings in 2012. Construction works are underway in Yeregnadzor, Kapan, Sevan and Ijevan. Construction of the buildings was not an objective for itself. It was important to define certain criteria. There is a notion of zoning. There are three main zones in all the court buildings. Public, where the citizens can enter at any time. Restricted, where the offices of the judges and their staff are located. And no entry zone. Those are the areas where the arrested are kept on temporary basis. This means the court buildings were built preserving the main principles, which enables limiting communication between the citizens and the judges, the arrested and the citizens. All this gave opportunity to bring down the corruption risks. In one decade, necessary conditions for natural functioning of a system, which presents a cornerstone for any state, were secured. However, construction of buildings, provision of property and technical staff was only the material base. It was important to reform the contents of judicial power, introduce new norms into judicial practices, act openly and transparently. The first steps were aimed at improving the administration, implementing programs of modernization. The courts were functioning. Justice naturally was being exercised. The formation of courts was clearly defined. Structure of courts, however, the status of court staff was not defined. Moreover, the legislative regulation involved the judges in a rather extensive administrative work. In particular, if we take as an example of judges, the chairman of the courts as well, they were doing financial and economic work, management of human resources, which naturally was not in line with the status of the judge, with the principles of independence of judges and other principles. On July 7, 2006, the law on judicial services was passed. The Judicial Department was established, which was intended to fill in the administrative gap in judicial system. The department took up management of human resources, financial and budgeting issues, regulated the proper functioning of judicial system so that the judges and court chairmen have opportunity to deal with their direct job only, lifting other responsibilities from them. Along administrative improvement, systems of automation in the court were introduced, and the court database was being elaborated and expanded. A program of management of judicial cases was introduced, and today it is a reality when each staff member of the court, including the judges, are using the program or working with this software, inputting the information or receiving the required amount of information within the scope of their responsibilities. The data center has been created in the judicial system. All the courts have been centralized due to this software, including the court locations. Each court inputs the received information via computer into a central point where the general information regarding the court case is being accumulated.
Well,
if previously we were trying to get any kind of information from the courts by means of court staff, today it is not needed anymore. We can receive the required information within seconds. In administrative terms, this is a far more mature and contemporary method to supervise the court cases. Prior to introduction of system of management of court cases, Armenian experts who had visited the US due to an exchange program, in an interview to a renowned Armenian newspaper, declared that the introduction of the system in the Armenian judiciary will give its fruits over a short period of time. That was the time when computer literacy in Armenia was not high, nor the internet accessibility. In just few years of technical progress, the work throughout the judicial system using this system became a more than common process. The system of management of court cases, which has become so important for the judicial system over a very short period of time, could not become comprehensive unless DataLex system was introduced, along the functioning of Datalex.am website. Combined functioning of system of court cases management and DataLex resolved two crucial issues at a time. First was the efficiency of administration of judicial power and internal management, while second looked at making the work of judicial power transparent, accountable and accessible for each citizen. And after 2009, possibility was created for everything related to the start, process and end of any court case heard in each instance to receive information online via internet, as well as due to equipment installed in courts and other state agencies. Even if the judge wants the court session not to be transparent, this is impossible if the citizen interferes. The DataLex software now registers the work of all judges, the schedule of the court sessions, the names of the sites, or what kind of criminal, civil, administrative case is being heard and against whom, and any citizen can freely receive the information. The verdict passed by the court is fixed in the software too, and any citizen can see it by just using a computer. It is a very big opportunity, especially for journalists covering the judiciary system. You are located in your Yerevan office and you can quickly follow the process of any court case across the country. There was an interesting case with one of our journalists. We went to participate in a hearing of a case based on a filing from a local bank, and the representative of the bank solicited to have a closed session out of bank secrecy considerations. However, as there was no bank secrecy in the essence of the hearing, the judge did not agree to have a closed session. Instead, he offered the journalist to leave the courtroom. The very same day when this journalist was preparing an article on this, the judge posted information regarding the court decision on Datalex.am website, where the information read that the case was heard at an open court session. We decided to apply to the Justice Council to discuss the issue, but a few days later, while we were working on that complaint, we had to go to Datalex.am website again, and we noticed that the open court session was changed to closed after our article. It is very important that we manage to control and keep the issue in our view. Prior to introduction of DataLex system, Arlis legal information system was set up in the frames of public awareness program. Any legal act accepted in the Republic of Armenia should be available to any citizen of the Republic of Armenia. That was the issue, after implementation of which the specialists should state that Armenia became one of the few countries where the legal acts are open and accessible by everyone. Prior to that, the state was releasing paper information, like the official bulletin, which contained, in fact, legislative acts, but that publication had serious defects. First was its price, and second, the updated versions of the legal acts were not reflected in the bulletins. If you remember, there was IRTEC, a private system, and it still functions at present. It offered a search service. However, it had some drawbacks too. It was too expensive even for professionals. And it was on the agenda to create a system which would make it possible to make the legal information accessible to citizens, allow them to use the legal acts. It was posted on the website to secure accessibility. The system is free of charge. Since the beginning, it was decided to have it free. Later on, a professional version of the system was developed as well, which is now presented on a CD. Making the legal acts public is a tool to raise public's legal awareness, a guarantee of freedom to search for information. Moreover, it facilitates the lawyer's work as well, as the lawyers very easily can find the legal acts using the search system. With that, the judicial acts are posted in that system of legal acts as well. And very often, we attempt to find respective cases with similar factual circumstances. Our list system encompassed a few dozens of thousands legal acts accepted and defined in the Third Republic of Armenia. The number of visitors of the information system proves that this is one of the most frequently used among websites of state institutions. The service of compulsory implementation of judicial acts was reforming as well. The typing machines were replaced by computers. Procedures requiring much time and efforts were changed to automated systems. Inquiries regarding property of the debtor to commercial banks, State Registry of Cadastre Service, are sent and responses to them are received in minutes. Previously, days were needed. Upon the launch of Judicial.am website, the number of complaints from dissatisfied citizens regarding compulsory sale of property went down sharply. Information related to conducting auctions is now available from the website as well. Participation in electronic auctions is possible for any citizen. The reforms in the service of compulsory implementation of judicial acts continue. Technological intervention in judicial area was able to solve probably a more important issue than the facilitation of work due to installation of contemporary equipment and related possibilities. The entire system became more accountable and open. Introduction of recording equipment in Armenia's court was another step in this direction. At first, the experience of introducing recording system in other countries was studied. From 2005, in Armenian courts, the Themida system was launched. The court sessions were recorded in real-time mode, and the recording on CDs became an inalienable part of court cases. Before, the entire court session was protocoled by a secretary. There was no guarantee that the written or typed minutes of the session would not be proofread or edited voluntarily by any judge. It could happen that the opposite side would come out with certain statement or accept some fact which was not registered by the secretary, and later it would become a matter for dispute. Or the other way around. The person would say one thing while the secretary would note something different, and there were cases even when the judge expediently would lead the case in a different way, creating certain provocations. Of course, the lawyers had certain tools to confront that. They would take a recording device with them to make recordings of the court sessions by themselves, which initially was not permitted by the judges. There was a moment when the lawyers overcame the obstacle and became recording the sessions. However, after the establishment of the recording system in the courts, these risks were nearly non-existent any longer. Moreover, the lawyer's work has been facilitated to the extent that when a letter of appeal against a court verdict is being filed, it is possible to obtain a CD with information, the recording, and while listening to it, try to recollect what happened in the court. Or, in case the lawyer has missed the court session, try to obtain information on what had happened and construct the application following from that. This is, for instance, a criminal case filed on the basis of complaint by citizen Hagopian. A CD is attached to the case. The entire protocol, in a compact manner, is on this disk and is maintained jointly with the case. if the site applies to obtain the CD, it is presented on the basis of respective application and in appropriate terms. For the first time, it is presented to the site free of charge. The cases that are over, receive a legal power, are then maintained in the courts for a certain time. Then they are submitted to the Central Archive of the Judicial Department, where they are numbered, classified, and archived by the Central Archive. Respective documents are then separated, after which some parts of the cases are destroyed. Currently, a program is being developed, and we will try to digitize the whole archive, instead of slowly sending paper documents related to cases from the Court of First Instance to the Court of Appeals, from Court of Appeals to the Court of Cassation. When the judges have to wait for the documents to arrive to them, the documents will be forwarded electronically. The judges will receive the documents, will be able to start work prior to the paper documents being attainable by them. The main addressee of the reforms carried out in the country is its citizen, expecting unbiased approach and priority of law by the judicial agency. The citizen should first of all be aware of their rights in order to fully exercise them. From 2009, Court Hour TV program presents to the public the judicial system and the ways to protect the rights with legal means on public TV. These TV series became a successor of another TV show. From 2005, the first channel aired My Right.
When
the shooting began, I was working at the ministry. I was the deputy minister. That was a new work, additional workload, because in order to make each program understandable, a great amount of work was done. On the other side, that was a completely different world, a TV world, where dual rules existed. The right on the one side and TV on the other, broadcasting with its own rules. Good evening. The court session will be chaired by Judge Tigran Mukuchian. All rise. When the first TV shows went on air, the most frequent question was, are those real disputes or not? There were disputes taken from everyday life. There were ones that were presented by the very sides that in reality had the dispute. But all this was secondary. In my opinion, in any case, the accent has always been that you need to follow not the shape but the content. What's important is that the key subject line which laid in the basis of each story was understandable for the audience. Presenting most complicated legal problems faced by people in their lives in a simple and comprehensive way, as well as ways to solve them in conditions of lack of legal literacy, is not an easy task at all. That was the key goal of My Right. The program used to inform on courts' functions and rights of citizens of Armenia, defined by the legislation. The public was gradually developing an understanding that traditions being agreed upon in a traditional way do not fit the rules defined by contemporary legal relations. Very often we use very different terms while conducting various transactions. For instance, when selling apartments, people say, I have given a deposit. However, very few know that the Institute of Deposit has been fixed in the Civil Code, that it's a civic and legal institute. It has its definition, regime of legal regulation. It was an issue related to, let's say, the transaction of a loan. The top issue here was that in any circumstance, unless there is at least simple but written receipt in the basis of the transaction, in the future, if a dispute arises, there is no proof or testimony by witness that can be attributed to. My Right had 3 broadcast sessions with 40 cases presented at each session. 120 different cases, each of them clarified functions of civil legal institutes. My Right twice became the best TV program of the year, had its website through which the experts were providing legal counseling. The citizens seemed to begin realizing the value of their right. And later, there were quite a few of cases in the judicial system Even the judges who used to work some time ago were telling this, when people in court were referring to My Right TV program. Very often, nobody knows why. When presenting a receipt, they were telling that they had heard on TV that the receipt had been formed based on this or that regulation. I have to mention that, in this respect, due to this activity, as a result of discussions in terms of own rights being recognized by people, I think that the program has reached its goals. On September 28, 2005, the National Assembly of the Republic of Armenia, after a year-long acute political debates, numerous consultations and active discussions, passed the project of constitutional changes in the third reading. The disputes and discussions that developed in the social and political circles before that pursued one goal: to select the best out of several proposals, due to which Armenia would have really reformed constitution. On November 27, 2005, 1,411,711 citizens of Armenia voted for introducing the changes. One of the key goals and important principles of the constitutional changes was the creation of guarantees for independent and self-governed functioning of the judiciary. The judicial self-regulating bodies should have assisted in implementation of this objective. The Justice Department, in its new composition, was supposed to do this work. The impact of the executive power on judiciary was to be reduced as well. In 1998, we in fact had two institutions that worked to secure autonomy of the judiciary system and introduce mechanism of self-regulation. Those were the Justice Council, a constitutional body, and the Council of Court Chairmen, created on the basis of the law. In 2007, we had an essentially different picture. We had the Justice Council in a different composition, by far more independent than before, without executive power, without the President of the country, without the Prosecutor General. We had a disciplinary committee of the Justice Council, which was established right by the Justice Council. We had Council of Court Chairmen and two more committees inside it, the Study Committee and Ethics Committee. And after all, we had the General Assembly of the Judges. Those are mechanisms. By creating mechanisms solely, we cannot yet guarantee that the courts will immediately become independent, unbiased. But those are the mechanisms that, while being put into operation, form a really independent and unbiased judiciary power. Parallel to changes following from new provisions of the Constitution, the work to improve legislation based on the accumulated experience in Armenia was continuing. Guarantees of proper functioning of the courts, judicial self-management, status of the judge, the principles of functioning of judicial power were regulated by a single document. In 2007, the new judicial code was accepted. A separate chapter here was devoted to rules of behavior of judges. Comments to them were written as well, to secure universal application of those rules. The principle was just one: the person who is entitled to execute justice, not only inside of the court, but in everyday life as well, since the very first moment, employs responsibility and obligation to abide by defined ethical norms. Rules of behavior help the judges to properly organize their household life, their work. Because of violation of those rules, the issues related to a number of judges have been discussed in the Ethics Committee of the Council of Court Chairmen. And unfortunately, there have been cases when some judges were liable to punishments because of violation of those rules. Creation of preconditions for civilized communication between the citizen and judicial body had its input in the issue of changes of public perception of judicial power. Already while reforming the courts of first instance, the number of court applications for civil cases went up sharply. The citizens began realizing the opportunity of restoring their rights by legal ways. The Institute of Judicial Precedence was introduced as well, to introduce similar application of laws for similar cases, and passing of verdicts based on cases tried previously by courts of higher instances. In civil cases, one of the sides is certainly dissatisfied. If interests conflict with each other, one side is sure to be unhappy, and they are frustrated or think about being deceived, or their interests have been violated. But when you make a precedent decision, the citizen is then convinced to a certain degree that their interests have not been violated, and as a result, the number of complaints is going down as well. Development of administrative justice began in the Republic of Armenia. Prior to constitutional changes, in 2004, Law on Administrative Basics and Administrative Proceedings was passed, which looked at regulation of relations between citizens and state institutions. The specialists of administrative right were to later name the law of specific constitution for state agencies and officials. The law regulated a whole chain of legal relations. The rights and responsibilities of persons or legal entities and administrative institutions were clearly defined. The most important work was done in the period of 2006 to 2008, when we developed a comprehensive program in the sphere of administrative right, conducted training jointly with our German experts. I have to state happily that the majority of those who passed the trainings were later appointed judges of administrative court. And as of January 1, 2008, we have justice specialized in administration. An administrative court was created. At first, the administrative justice was made of two steps, which means we had administrative court and the court of cassation. Later on, when administrative justice got its flesh and blood, the need came up to create an immediate second circle, and as of last year, we already have Administrative Court of Appeals. It has already become such a usual thing that a citizen can sue the state and win the case as well. But say in 2000 or in 1990s, it was difficult for us to even imagine this. I'm now going to participate in a court session where a citizen sued the Ministry of Transportation and Communication and the Department of State Cadastre to recognize a lease agreement invalid. The process is okay. Let's hope it will be over in a proper way. A week ago, I sued the Ministry of Urban Development. I won the case. I don't see any problem in suing any state administrative institution. In this respect, the reforms have reached the level when I can bravely say that the court is not confined to try even the government or any other ministry or state administrative institution. The same requirements exist for judicial powers of all kinds of countries, developed and developing, having a history of millennia or just a few centuries. Each citizen should realize that the judge, while exercising justice, has not been influenced in any way and has been ruled merely by his conscience. And even if the citizen is not satisfied with the judicial act, it still has been made in equal opportunities and in a fit manner. To reach this goal, all the measures were taken that were targeting the shaping of a new quality of justice and the increasing of public legal awareness in Armenia, which was overcoming the consequences of political and social crises of not so far past. Reforms in judicial area began right at that time. That was 15 years ago. In general, when kids are growing, very often you do not see them growing, but once you go through the old photo albums, only then it comes to your attention what great changes have taken place. The same can be said in our society. If we compare the society today with that in 1998, in terms of legal consciousness, responsibility, preparedness, we will notice essential difference, but in our everyday life it seems to pass unnoticed. For this, we really need to go back to history, see what types of questions we used to discuss then, what kind of complaints we had, what our citizens were dissatisfied with, and we'll see what a huge leap we have made over the past 15 years. The second stage of judicial reform will be over by 2012, but a new stage will begin. For a state to develop, to grow, to to create all conditions to secure natural ways of society's life. The basis should be put on the idea of progress. Otherwise, reform implemented in any sphere will not stop having a power of development once it stops for a moment.
Life
is developing, and any period in society's development poses its own questions for the judicial authority as the most important element of effective functioning of public organism. Currently, a program of judicial reforms for 2012-2014 is in the process of elaboration, which will be much more comprehensive, bigger in scope, embracing more activities and steps. It will encompass not just the reforms of the judiciary, but also reforms in such auxiliary and adjacent institutions to it as the prosecution, advocates, Office of Vital Records, notaries' offices and other. And in many cases, solutions to the problems have to be found in these levels, and changes here have to produce their positive results in the judiciary sector. And if we try to generalize and comprehend what kind of state we want to have, then any citizen should pronounce two things without hesitation. We want to have a secure, protected state, for which we need to have a powerful army, effective security system, and before that, a justice system, to live in such a country where justice rules. There are around 200 countries in the world. They are classified based on political, ideological and religious directions, degree of economic development, according to how they manage their foreign policy, how they regulate social relations inside the country, what models of internal management they use, and so on. With differences in nature and at the same time being similar entities, for all the states and societies, the most important requirement is the same: equal implementation of the norms for all the created codes, legal and legislative, application of compulsory norms for all, and their improvement for the sake of general benefit and implementation of justice. No country stops on this road. Armenia is moving along a predefined path. The judiciary reforms are still going on.